Well, good morning, everyone, and welcome to day 4 of Washington Arbitration Week. I see a lot of friendly but maybe a little tired faces of the folks who've been at our sessions all week, and so thank you for your attendance, and thanks to those virtually online dialing into this morning's session. Let me introduce myself for those who may not know me. My name is Ian Laird. I'm a partner here at Crowell Moring, who is, we are hosting this morning's first 2 sessions of the day, and I'm very happy that we can do so. The other hat I'm wearing is as co-chair of Washington Arbitration Week. So I would like to thank Crowell Moring. Thank you, Ian. Yes, you're welcome. But Washington Arbitration Week is now in its 5th year, and I think this week we've shown that we only go from strength to strength and are continuing to grow and develop new programs, and the enthusiasm of the law firms and the support organizations, the experts and the institutions has been extraordinary. So thank you to all of our sponsors and supporters. You know, without your efforts and all of your organizational skill and technical skill and enthusiasm for international arbitration, obviously we couldn't make this happen. So thank you again. I can't say that enough. This morning we have a panel which really hits at very much a cutting edge issue. And we always like to do at least a few panels on technology related issues, but the panel this morning is particularly current, and I think we're going to hear some interesting perspectives from our panel. The title of our session is The Tech Revolution in International Arbitration, the Impact and Use of AI on Lawyering and Adjudicating. So very much looking forward to that. Our moderator is Annie Lesperance. She's the head of Americas at Jus Mundi, which is, of course, the well-used, certainly by me and many others, I think, in this room, website of international arbitration materials. You know, the case law collection is fantastic. It's now developed a whole collection of articles and treatises and books. And of course, its arbitrator data is par none. And it's really a pleasure to partner with Jus Mundi. They've made huge strides. I know the AI element is something that they've been very active on and in the forefront. And I think this is great having Annie here. And she in particular has had a wealth of experience in international arbitration. She's worked for funders at Omni Bridgeway. She's been counsel working with Yves Fortier and Cabinet Yves Fortier in Montreal, and as well as working at one of our top institutions, the Permanent Court of Arbitration, as counsel. So we are in very good hands this morning with Annie, and I want to thank Annie for her work and thank the panel in advance for agreeing to come to this session. And I will pass the microphone over to Annie and let's get going. Thank you, Annie.
Fantastic. Thank you very much, Ian, for this introduction. Thanks to Washington Arbitration Week, to the co-organizers, to the entire team at X Strategy for helping with the logistics of all of this. And thanks obviously to Ian and your firm for welcoming us and hosting us on this windy morning here in DC. We have a fantastic panel lined up for you today, and we are honored to have with us a powerhouse panel of tech and arbitration enthusiasts. Each of them bring their own special perspective to our topic today. And I will let each and every one of them introduce themselves, starting with Liz.
Hello, everyone. My name is Liz Dye. I am a senior associate at Pillsbury Winthrop Shaw Pittman in Houston, and I focus on construction litigation, investor-state arbitration, and commercial.
Kelby?
Hi, I'm Kelby Bellina. I'm a specialist at Hughes Hubbard and Reed. I've been working as a paralegal for about 25 years, but recently in the last 3, working with business development and client development, which is one of the things we're probably going to talk about today. Things from networking to building firm profiles and really finding how the money is made in collaboration as opposed to competition. Currently on the mediator for ITA and review, on the communications board there, and explore the area of, thank you, of legal ops and legal technology.
Thank you, Jeff.
Good morning. My name is Jeff Sanger. I'm an arbitrator and mediator with JAMS, also on the panel of the Singapore International Arbitration Center and CPR in New York. Before joining JAMS, I was an international life sciences partner at Sidley Austin and was the acting general counsel of the Food and Drug Administration. So I do life sciences cases. I'm also a professor at Columbia and Harvard Law Schools.
Thank you. So today our panel will be divided into 2 segments. In the first, we will discuss the various types of possible use cases for AI in arbitration. We'd like to show you some practical examples of how you can leverage AI in your daily practice, but we'll also discuss the risks associated with the use of AI and emerging guidelines and regulations that are trying to address and curtail these risks. And in the second segment of our panel, we will discuss the transformative impact of AI on the legal industry. So let's kick it off with our first segment. As you've heard, we've had the benefit of having an arbitrator, counsel, and paralegal, and a representative of an AI provider on the panel. So I'd like to do a little bit of a tour d'horizon and ask each of you to explain a bit how do you leverage AI currently in your daily activities. And perhaps let's start with, we'll follow the same order. So let's start with Liz.
Sure. In my practice in particular, I see a lot of benefit in, especially in, investor state arbitration. You have these really long awards, really long decisions, arbitrators with, storied careers. And so a lot of decisions piling up. And so I think AI is a great tool to really streamline the initial research and analysis, and analyzing those larger data sets much more quickly and efficiently than you could do on your own. Like for example, I'll share my screen. Okay, thank you. I remember one particular assignment I had early on when I was a junior associate, and I was told to look at all of the preliminary measures decisions of all the arbitrators on the panel. And that was a big task. So I thought I would give you sort of an example of how you can use. Our firm in particular uses ChatGPT. We are currently licensing people who have completed training. So this is an example of how I would use ChatGPT in my practice. So this is a recent preliminary measures decision in the RTI case. I think it came out like very recently. And so, I almost talk to ChatGPT like it's a junior associate. You really need to give it a lot of detail. So I gave it a prompt. I said, you're an associate at a large law firm. You're focusing on international arbitration disputes. You've been given the task of analyzing a recent decision. A copy of the decision is attached. So I attached the document, I attached the decision. I asked it to create an outline and a chart Sometimes I create my own chart in Word or PDF and I'll feed it in so it'll produce kind of exactly what I'm looking for. And so when I asked it in particular to start with the parties, the representatives, arguments, the claimants, the respondents, and then the tribunal's decision and what test in particular they focused on for the decision on provisional measures. And so it started with this outline and it gave me a really nice summary that, I would have started with, and it would have taken me time, but it's really easy for it to just summarize, pull these facts out. I know who the representatives are. It goes through the key arguments. So there was the prima facie jurisdiction. And then it said, okay, well, the claimants focused on necessity and proportionality. It kind of gave 3 bullet points. And then it went through the respondents' arguments. And then it went to the tribunal's decision and it said what legal tests they use, the findings, what they ordered. And I said, okay, that's great. Here's the summary chart in case that was something that would be helpful to me, because I like to see things in a couple different ways. And so then I said, can you please identify the tribunal members? Because I'm interested in kind of seeing how they, sort of their precedent, how they make decisions, and identify the arbitrators. I said, great. Can you look through publicly available decisions, procedural orders, or awards on provisional measures issued by these tribunal members, create a list for me? Which is all things that I would have had to do, combing through the various websites that have all these publicly available decisions. And it would have taken me, probably hours, whereas ChatGPT can really synthesize that process. And so, okay, well, it didn't quite understand my question. And so it really only focused on the procedural orders in this case. So I said, okay, thanks. I don't want that. Can you actually look at, other decisions in other cases? And so then it gave me the list of their decisions, including this one in other cases. And then, the next step, I think I said, oh yeah, are there any decisions in particular that these tribunal members tend to rely on? So you kind of know like, okay, well, this is what's interesting to these particular arbitrators. This is what they find convincing. And so then it created a list, and you can really go on and on in this vein, just specifying different criterion that you're interested in. And so I find that helpful in particular when you're dealing with a really, really large data set to initially sift through everything and kind of get a really nice, quick list. And then I think, our task as counsel is to then go through and read the particular decisions that we find interesting, make sure that ChatGPT isn't hallucinating some case that doesn't exist, make sure these things exist. And then that just really helps kickstart your research and focus on particular things. So, I mean, I find that that's a great value out of ChatGPT is just starting your initial research. And let me see what else.
Yeah, I think
okay,
that's
perfect.
That's good.
Okay, thanks.
I appreciate
I don't want
it.
to take up too much time. Sorry.
No, all good, Liz. I think what this shows is really how useful and impactful and at time these types of tools are very much allow you to save a lot of time in order to do some summarization tasks, as you've pointed out, Liz. These are great tools for that. But Kelby, how do you use AI in your daily practice?
So luckily, I have the luxury of being able to test and beta test different types of models just for the idea of my job is to help the attorney do what they do best. But there's many ways of doing that because there's many different fields. Between international arbitration, there's also many different fields from commercial and investment. But with that that said, there are brainstorming tools out there, and one of them was ChatGPT. And I usually develop it, but I've come from firms where it's been restricted. So finding the benefit is sometimes a little difficult. So you have to sort of explore and look at, well, what other AI tools are out there to find that brainstorming sort of component. But the other use is things like legal research, writing, being able to find, there's so many platforms out there that can help you with these tasks. And they're all out there, including Gismundi. And not only that, the world has really changed as to how we used to really profile ourselves in law firms. We are also thinking about audio, thinking about video, what we're posting on LinkedIn, how we're presenting. Now we're on Zoom, doing hybrid hearings, things like that. So audio and video are very important. How do you go ahead and practice your opening statement, for example? So one AI that I would say I would leverage is Descript. Go ahead and do your entire opening and see what the AI will tell you. It'll say, well, hey, you are repeating a lot of words, or you're breaking down filler words every now and then. So something like this is an example of what you might see, what the AI will help you with. I actually use this for a podcast. I have a podcast at The Advocate Next Door. And anytime we finish an interview, I'll go through this and see, like, well, are there repetitive things that we can sort of cut so that the interview sounds a little bit tighter? But also things like videos, like, well, can we convert this into a presentation? You can quickly just add video here and there, add captions. All of that is really key these days. Things like teaching also, many lawyers do have positions as professors. And calendar management, project management. How many people have difficulties with their calendar, finding that pocket of time? Can I go up to somebody right now and say, when are you available for coffee? Do you have to spend a lot of time trying to figure out when your next availability is? Do you lose that client opportunity if you say, I have to get back to you? So there are a lot of other AI platforms out there. And I just encourage you, we don't have enough time, but I just encourage you to kind of do your research. And the big one is the one that we always forget is hardware. AI and hardware is crucial. Everything from the webcams to the cameras that we're using now. Do they follow you? Do they zoom in? Are they available for hybrid models? Do you use them for discovery? Is the person who is looking at the document on your computer the person that should be looking? What happens if I look over her shoulder? Will it block my view? A lot of times that answer is no, because we're not using the right technology, but that would be really important for discovery. One of the topics that did come up in other panels was the usage of drones. And drones can be an entire 2-hour panel because we can talk about how we are using that in commercial and arbitration and to prevent issues. They can go from infrared scanning of solar panels, mining, pipes, gas, farming. I don't know if anybody out there has clients that in the agricultural area, in the mining sector, in the seabed mining sector. They're all out there and they all have their usage. And unfortunately, we can't get into the details here, but also being able to count stockpiles instantly, monitor construction. How useful would this be data-wise to not only help in an actual arbitration, but to prevent an arbitration? And also integrating into things like the metaverse, being able to control a drone from home, 1,000,000 miles or 1,000 miles away. Now it's being integrated into robotics. And that's an entire topic at itself. So AI has a lot of benefits that many of us are just not getting into. And we're still at the ChatGPT phase when many of our clients are already way ahead of us.
Thanks, Kelby. There are so many tools out there, and for those of you who are trying to navigate these types of tools, there's a fantastic website. Maybe I can share it on the screen quickly. It's called legaltechnologyhub.com. And that website lists thousands and thousands of AI tools out there for different types of practice area in the law, and for different types of use cases. So here, for example, this is the landing page. You could type up, for example, arbitration, and you would see a number of tools, including use Mundis, in this space. Then you can click on them and see what they offer, the types of use cases you can use these tools for, etc. So it's a nice way to navigate the complexity of what's being offered out there. Jeff, how do you use AI as an arbitrator? Do you use it, if at all?
I do, and you have to stop sharing. If
I will.
All right, so I use arbitrator in about 4 different capacities, different things I'll do, and I'll close with as an arbitrator. But as a professor, I have used it probably daily. And one of the ways, in fact, is to draft quiz questions or exam questions at the end of the semester. And I am concerned that the students are going to use AI to answer the questions. So yesterday I asked Perplexity, which is one of the sites I like to use, how to draft final exam questions that the students could not use AI effectively to answer. And it had a very useful and detailed response for me, suggesting context-dependent questions, as we discussed in class, give your personal experiences, things that AI would not be able to answer. It noted AI is not as good as at abstract thinking as it is with specific thinking, concrete thinking. I have a draft slides for me, create images. If you want to say when this will happen when pigs fly, it'll give you an image of pigs flying that you can put up on a PowerPoint, and the students like that. As counsel at Sidley, I used AI quite a bit, largely for document review. And I left Sidley and joined JAMS before it had really kicked in. But I think as counsel now, I'd be using it all the time. The idea that you can take thousands of pages of depositions and they're analyzed instantly in several seconds. It'll go through all of them. And I would ask it to identify inconsistencies between different parties, to suggest areas for further development, for further examination. It'll suggest questions for depositions, questions for cross-examination. It's a profound tool that I think will dramatically change the arbitration practice. As a mediator, I don't use it that much. As a neutral, I don't use it that much, but I'll use it for factual things. As an arbitrator in particular, I am hesitant to use it for multiple reasons. The confidentiality is probably the first. I don't think I can enter into a large language model database any of the materials that the parties have given me, because I don't know where it goes. It goes somewhere. It's stored somewhere. It may or may not become part of the large language model that could be publicly revealed in various contexts. You can purchase a separate folder where your material may allegedly be kept confidential, but I'm not quite comfortable doing that with the materials the party sent me. You could use it to help analyze cases, but as an arbitrator, I'm not yet comfortable with that, because I think the parties pay me for my judgment and my experience, not the judgment and experience of ChatGPT or Gemini. So I have not been using it a whole lot. The final thing is you can use it for research as an arbitrator, but I don't like to do a lot of outside research. I'm at the school that the parties will tell me what it is they want me to base the decision on, and don't want me doing a lot of poking around in other areas. So as yet, it has not revolutionized my work as an arbitrator, but it has in other fields.
Thanks, Jeff. Some of you mentioned use AI, so I thought maybe I will show you a little bit what we've developed at Jusmundi. Here we go. So for those of you who don't know Jusmundi that well, we've built the most comprehensive database for primary sources in international arbitration, and this is thanks to our partnerships with more than 80 arbitration institutions and associations worldwide. The data that we've collected include, yes, data available from publicly available sources as they relate to arbitration, including national court decisions on enforcement and setting aside. But we also collect exclusive data coming from our partners that are not necessarily available elsewhere. So with, the whole game in related to Gen AI is a data game. You want to have the best data to be able to provide the best outputs. There are two types of players, I would say, in the market. You have the, legal tech companies that provide external legal data so that users can actually do legal research through that data. But you also have then the other players that only deal with, a law firm's own proprietary data, like the Harveys or these types of tools where you upload your documents to the tool. And now what is happening is the traditional providers that have these, this external legal data are adding a layer of Gen AI on top. This is what we have done now at Jusmundi, but we've also allowed our users to interact with their own documents too. So as a user of UCI, you can either interact only with the entirety of our database for legal research, or you can upload documents to the tool and interact with those documents, do summarization, drafting, etc., or interact with both. And that is the added value that I think we bring to the table, at least in this niche area, which is international arbitration. So I'll take you to the platform a little bit. So this is the landing page. You see UCI here at the top. You have some suggestions as to how you can use the tool. And then you have here the search bar where you can type up your requests. We have our prompt guide, which provides you with fantastic tips as to how to maximize the value of these tools by doing good prompting. And so some of the tips include, you saw some of the prompts that Liz made, giving context, being clear and specific, breaking down complex prompts. If you're not happy with an answer, dive into the tool, continue asking questions, expand, and all of that. So here I'm going to ask a legal research question. How can you use an MFN clause to avoid a fork in the road provision? Please provide, because I'm being polite with the tool, please provide precedents or awards that support this point. And so now the tool is searching the entirety of Jusmundi's database to the exclusion of the World Wide Web. So it's not like a ChatGPT that also takes information coming from the World Wide Web. This is only limited to Jusmundi's data. And this is how we mitigate against the risk of hallucinations. Because you'll see for every statement made by the tool, there is a footnote. And the footnote refers to a document that exists on Jusmundi that you can go and double check. You see, you get obviously a response in seconds. It's not necessarily a perfect answer, but it is an answer that you get quite quickly. It gets you quick ideas. And here you have, again, a table explaining some of the case law or awards or even publications that are on Jusmundi on this point. Again, you have all of the sources. You can click on them to verify that that the source is accurate. So here you would click, let's say, on this first one. It would take you to the actual paragraph 315. It takes you to the document that exists on Jusmundi. It takes you straight to the paragraph or the section where the information was taken from. Now I'll show you another example. I'm going to start a new conversation with the tool. And I'm going to upload a document now. I'm actually going to have pre-uploaded some documents here to the tool. So I'm going to upload the Vismut problem of last year and the claimant's memorial. This was a case under the ICC rules. And now I'm only interacting with those two documents that have been uploaded in a safe and confidential, obviously, manner. We are not interested in retaining any documents. So those are automatically deleted after 15 days. So now I'm going to ask a simple question, a summarization question, summarize the factual background and list in detail the claims supporting the arguments made by claimant. Again, you get a summary in matters of seconds, again, with footnotes referring exactly to where the information was taken from in those two documents. You've seen those were two PDF documents as well that were uploaded. And again, I'm only interacting with Jusmundi, those two documents. Now, I'm counsel for respondent. I'm tasked with developing some counter arguments on some of these claims. I want to only, because it's better to break down the prompts. So I only want to understand the test to authorize the addition of a new claim, which is one of the claims being made by claimant here. So I'm asking the tool, can you outline the conditions under which new claims may be introduced in an ICC arbitration? And you saw I clicked on the toggle use Mundi data, so that now I'm interacting with both the documents that I've uploaded and also use Mundi's database, which is relevant and useful in terms of a legal research question to search other sources of data. So you see the sources coming from use Mundi's database and the documents themselves. And now I'm counsel for respondent. I want to draft my counter memorial, so I can ask the tool to draft this in that style, draft the counter memorial on this precise point, incorporating the relevant facts and legal arguments to demonstrate why the addition of a new claim should be rejected. I'm not saying it's necessarily a perfect draft, but you get a draft in seconds. A first one at least, and then you can copy, paste it to a Word document and continue working on it. So with the interest of time, I'll move to the third example I wanted to show you. This is to show the multilingual capabilities as well of a tool like this, especially in a context, in international arbitration, very important to be able to work across languages. So here what I'm going to do is I'm going to upload the Rutas de Lima transcript. This is a 310-page transcript in Spanish. And I'm going to ask the tool to summarize the testimony of Alfredo Boulard, who was one of the witnesses in the case. I see one of the experts is in the room who was in this case. So I think, this summary is a bit short, so I'm going to ask the tool to expand on it. I mean, this was a multi-day hearing, so a four-liner is a bit short. So I'm going to ask the tool to expand again. So if you're not happy with the answer, you can, continue. And I suggest continue interacting with the tool. So now you have a more detailed summary of his testimony. Again, so it's taking from a document in Spanish and then translating in English. Now I can ask the tool to identify any weaknesses or contradictions in his testimony. This is very useful when you're drafting your post-hearing briefs to double check whether there are any angles you may have missed during the hearing. Again, done in seconds. And then you can also ask the tool to draft cross-examination questions for Alfredo Boulard on the basis of these weaknesses and contradictions. Now, these are a bit broad questions. Can you explain, can you clarify? Two broad questions. So then you can continue interacting with the tool and ask the tool, can you redraft these questions, but in a leading way and with a passive aggressive tone. Isn't it true, Mr. Boulard? And then you can ask the tool to translate all of this in Spanish. There you go. So I think, as we've discussed a little bit, I think with the examples that we've shown this morning, these types of tools are fantastic in terms of, summarization, translation, for everything that is related to legal research as well. Whenever you're looking at drafting, they're not meant to replace, the lawyers or the associates or partners on the case. They're really there to get you to that first draft much more quickly, and then to continue working on it. And also it's like a sparring partner. It helps you in that creative iteration process of coming up with the arguments and making sure that you haven't forgotten any blind spots potentially. With this being said, there are certain risks associated with these types of tools. And perhaps we should dive a little bit into discussions as to what types of risks do they present and how can we mitigate against those risks. And so maybe I'll ask Liz to start with that.
Sure. So I see the first risk, and I alluded to this earlier, is hallucinations. Sometimes ChatGPT will just make stuff up, like cite to cases that doesn't exist. I think we've all seen in legal news, lawyers who have gotten sanctioned for just turning in briefs that cite cases that don't exist. So you have to really make sure that you're checking the veracity of what ChatGPT or whatever tool you're using is coming up. Another one is biases in the data set. So all these tools learn from the data that's being fed into them. And these tools, the data itself may have biases in it. So you just need to keep that in mind when you're adopting, some of the reasoning or the analysis that the tools are spitting out for you, and be mindful that it may exclude some important data. And then I think, a big challenge is just difficulty with very, complex tasks and creativity. When Annie was going through her prompts, breaking things down into concrete questions, not feeding it too much at once, it gets kind of overloaded and garbled sometimes. And I think with the specific example of drafting, an initial brief, I think it's really useful for an initial preliminary draft. It goes for the obvious, arguments, and it just really seems to miss sort of those creative, nuanced, persuasive arguments and writing that really makes legal writing interesting. So I think you would want to avoid sort of using whatever the tool gives you as your final product. That's obvious, but then really think you have to do your own really complex high level thinking and what actually would persuade, an arbitrator or a particular arbitrator, or, where should this sentence go versus this sentence. I think that's really lost on the tools. And that's a big limitation in just your own work products that I see. So that's a summary of kind of the three big issues and risks that I see. And then in terms of mitigation strategies, I would just say briefly, training to the extent there are training and just being aware of these risks.
Calby, would you like to comment?
Yeah, just to comment on that. I totally agree. I mean, like there are these limitations here, and I think to think about how the AI is built. I don't know how many people here might have a different default than Google. Whatever is out there is what the AI is picking up, whether it's right or wrong. And I've been on Google many times and found something before, this AI revolution, and I found something that was wrong, but it's out there. Anybody could just write a website and put out information. Wiki is always, Wikimedia is always trying to correct and make sure that they can verify their sources. Yet the AI is grabbing from there. So the hallucinations make sense because it's just grabbing out of different locations. It's not determining whether it's right or wrong. So the quality is up to us. And it really, we also have to think about what's missing, because everything that's public may not be available at all times. I mean, how many of us have gone to a website and an article that we were looking for no longer exists because it might be old or may have been pulled? So the AI is going to be missing things. It's only going to know what it knows, except you don't know what it knows. So you really have to not just play around with it, but get to know it, get intimate with the platform, ask it questions, and get to know what it is that you're seeking. It's starting at a basic level and going from there. And I think that's also a difficulty, is the amount of time that it does take to get to a level where you can feel comfortable with it, because you need to determine, I guess, where the mistakes are, whether you use ChatGPT or some other software. You really have to get familiar with it. So that takes some time.
Jeff?
Yeah, I think the flaws in AI are profound and fascinating, but also exist in the human world. I mean, it was started by AI makes mistakes and has biases, but so do all of us. Sibley had good associates, but they got things wrong and they brought their own personal biases in as well. So AI doesn't have to be perfect to be useful or even to be better than the current world. But there is something creepy about the hallucinations. I don't know how many of you poked around in AI, but it will gaslight you. It comes right out with something as if it is God's truth, the same way, and it'll be either right or wrong. And much of the time it's right, and sometimes it's creepy how right it is. But it'll put the wrong answer just as confidently and straightforwardly and directly as the right one. So you have to double check everything. One tool I found helpful is an app called ChatHub, which will aggregate multiple AI sources on one screen. So if I just want a factual question, when did FDA regulate cosmetic eyelash enhancers was one I had recently for a mediation, and I wanted a quick answer, and ChatHub will pull up Perplexity and Llama and Gemini and ChatGPT on one screen, and if all four of them agree, I have more confidence that it's right than if just one of them does.
Thanks, Jeff. I think as lawyers, we have our ethical duty and responsibility to verify the work that the attorney work product that we put out to clients. But are those rules enough in this context, or do we need more, something different? What is the emerging legal framework around mitigating against the risks that AI present? Jeff, could you address that?
Yes, there is an emerging legal framework. Exactly, that's the way I would put it, Annie. I think it's in its infancy, and different organizations have gone about it in different ways, and I don't think it has been mastered yet, but we're seeing beta attempts. JAMS in particular was the first provider organization to issue a set of rules in April, and I'll talk about those, and then the Silicon Valley Arbitration and Mediation Center did as well, as I'll talk about later in this program. But the JAMS rules cover disputes involving artificial intelligence, where the subject matter of the dispute is AI. And it has to start with a definition of what is AI, and I'll talk about court rules as well, and then stop. So the definition is got to be the foundation of it, and it's a hard definition to write. And I don't think I've read one yet that is totally satisfying. The JAMS definition is meant, most of them I think do, talks about cognition. What is a process, a machine-based system capable of completing tasks that would otherwise require cognition, is how we sliced it. What is cognition? It's not easy. Does cognition include memory? Are hard drives cognition? Does it include algorithms like spell checkers or Google or spam filters or translator programs? Where is the line? I remember back to college, the definition of humanity. What is human thinking? Some of the definitions talk about what do humans do that no other animal does. And it's kind of hard. And think, well, we use tools was one that was thought of. If humans are tool users, then they found an ape that would break off a stick and use it to scrape off insects to eat. And I think the stick would qualify as a tool. And then they tried language. Humans are the only animals that use languages. But then this ape called Washoe, a chimpanzee, learned 350 signs. They taught her sign language, and she even created her own language. She saw a swan. She hadn't learned the word for swan, so she used the word water and bird, called it a water bird, which is creating language. So I don't know how we're going to limit this, how we're going to cabin what artificial intelligence is, but we start with cognition. The JAMS rules have a few provisions that they put in. Added protection. These large language models and systems like them are highly confidential and trade secrets. And JAMS recognizes that parties in using those processes will want protections. There's a presumptive protective order that goes in. And I should say all of these rules are presumptive and voluntary. My role is to give the parties the process that they want, that they contracted for. But these are suggestions JAMS gives. They are sent in view of the sensitivity. The expert witnesses are sometimes the confident, most confidential information is experts' eyes only, not even lawyers' eyes only goes to the experts. And then the reports can be reviewed, but not the subject matter itself. The courts are doing it in different ways as well, and we see a whole spectrum. In my experience, most of the courts are silent. They haven't figured it out yet. They don't know what it is. They don't know what they want to do with it, and they don't want to get too far in front of it. But some courts have been quite restrictive. There's one in the Southern District of Ohio, Judge Newman prohibits the use of artificial intelligence other than legal search engines. And that struck me as quite restrictive. Is a legal search engine only Westlaw or Lexis? Does that mean you can't even use Google to write your briefs? Other courts have said you must disclose whenever you use an AI tool for research or drafting. Sounds reasonable. Does that mean you need to disclose spell check on your Word? Is that an artificial intelligence algorithm? Some only require disclosure of generative AI or AI that creates output. Some require disclosure for others, some but not others. The District of Montana requires disclosure for people not in Montana. Pro hoc vice lawyers outside Montana, but they don't make Montana lawyers do it because they trust the people in Montana. And the Eastern District of Missouri, Eastern District of Texas prohibit pro se litigants from using artificial intelligence, but allow people who've passed the bar. Some of these, I think, may be challenged as discriminatory, and all of them, I think, are still working on figuring out where they want to be. So we'll see how it evolves.
Jeff, I think it would be very interesting for members of the audience if you could share perhaps, what type of guidance is being requested by parties in the arbitration proceedings where you sit as arbitrator. What type of guidance is being requested by parties in relation to AI?
Yeah, I think it's starting out for parties too. I think parties are figuring out what they want to do. If it's a tech case, the parties can be sophisticated. And in that case, they've often come up with their own proposals on how they're going to deal with confidentiality. The JAMS guidelines give some proposals, but if they're sophisticated, they know what they're doing when they come to me. And if they're not, they often don't even talk about it. But I think we're going to see it more and more.
Right. We have about 30 minutes left, more or less. So let's dive into the second segment of our panel. We'll talk about the transformative impact of AI on law firms as businesses. And so let's start with Kelby. As a paralegal, right, how do you see Gen AI impacting the workflow within a law firm? Let's start with that.
That's a very heavy question because there's so many ways that the Gen AI can affect. But just making sure I cover a bunch of different areas where this is.
Yeah, because it affects the workforce, the workflow, the workforce. It affects
how we work,
the billable hour,
right?
It affects the, how can ADR professionals, how can they learn about these tools, how they're upskilling, et cetera, et cetera. So, yeah.
So one of the things I would start with is that the legal industry is really behind. And I think most of us can agree that we're very slow to adopt everything from cybersecurity over convenience. A few of you might remember that back a couple of years ago, we had this debate about the cloud. Where are we going to put these documents? How dangerous is this? The cloud. And now we have documents on our iPhones or smartphones. Social media was very restrictive. Even today, things like Dropbox, Box, or something like that, you can't access a certain FTP site. So right now, the legal industry is really behind, yet we're talking about this AI that accesses a lot of that technology. Many firms decide to pick cheaper technology, I would say, PCs, phone systems, even video conference room systems that don't zoom in because they're not built for Zoom or for what it is today. So the legal industry is really behind in that area for many different reasons. But really, I think, food for thought. I was I was asked actually by Pillsbury's AI task force to join them at a congressional hearing, and the first thing they said to me at this meeting, every time that you use ChatGPT to ask a question, you're consuming enough energy to power 2 homes. Every time. That's a lot, right? And that impact can be enormous, from how you use it to how often you want to use it to just the immense cost, not only environmental, but the actual value of it. And the reason is, maybe some people don't really understand it, but the reason is if you can compare listening to an MP3 on or a tape deck to a vinyl to what it is today, the quality is different. Audio can be different. If you're ever watching a video on a VHS versus today, the quality can be different, but you can still see it. Data doesn't work that same way. You can't buffer data, because if you buffer data, you miss something, hence the hallucination. It needs to know point A, B, and C. If you skip B, it's going to hallucinate something for B to get you to C. So that's one of the reasons why it's so expensive. You have to have massive servers just to answer a question. So that's already really difficult. And not understanding that already puts you sort of at a negative. Why is it hallucinating? What is the impact there? In fact, there have been studies, I can't really go into this with the time, but it just consumes a lot, just a lot of energy, a lot of resources. And quite frankly, the players are huge. In this year alone, in the US, there have been about 5,500 new startups in the AI industry. So when I was showing you some screens earlier before about brainstorming, what other resources, maybe in e-discovery, there's hundreds of them. And trying to decide between one and the other is complex. At some point, we're gonna get through this AI burst. The bubble's gonna burst, kind of like we went through the websites. It's gonna burst, and we're gonna have a limited few. So then we'll be able to start redefining, giving feedback, and really focusing on a few key players. But right now, everyone has their hands on it. And so we're all trying to figure it out, and they're all providing hallucinations. Some of the companies are merging here and there. And really the change, and I guess to answer now these three questions, our industry is going to have to speed up just to catch up to all of the change. There's going to be, let's say from the 5,000, there'll be 10 that we use that does it all, because these days we're looking for one platform to give you an image from ChatGPT. Another one, we're creating music, we're creating briefs, we're doing discovery, so many different things. We're going to have smaller players to be able to do more of those on the checklist. And really, it's going to be, we're going to have this age where we're going to be less reliant on junior attorneys doing some of this brainstorming, trying to figure out the forms, because I mean, as you had just shown, this platform on Just Mundi, that's amazing. That's amazing that you can do that. How reliant is the senior partner going to be on a first year right out of a law school attorney, when I could probably test this out? So you're going to end up having staff, paralegals, maybe kind of like today we have staff attorneys to focus on discovery. You're going to have staff attorneys to focus on the AI and developing and checking the resources. Paralegals like myself are going to be more specialized in this technology, checking the technology, knowing what to look for. Right. So the structure of law firms will at some point change. It's happened in the last 10 years. We used to have legal secretaries who had one per partner. Things have changed with technology. Now most attorneys can type for themselves. And I think this is also going to bring in a new age of now you have this opportunity, you have all this free time. You could do in 3 hours what you used to do in 8. Well, the billable hour then doesn't really make sense because you're basically making your client pay for being less efficient. If you enter the world of legal ops, there's an entire community out there, thousands and thousands of people of legal ops. Most of them will tell you the billable hour does not make sense. In fact, I had a client, potential client, a huge company, and they told me that they give all of their business to this one firm because they don't do the billable hour. They just give them a flat fee that includes everything from the calls, questions about their discovery, everything. It just concludes everything. And they rather do it that way than having to go through hours of reading billable time that people hate. I don't know how many people like entering time to begin with. I'm surprised that this is still a thing. I mean, at our firm, we're exploring this option of changing, or at least for those companies that want to do it this way. So there's a lot that AI is going to allow us to rethink. And we've done it before. Again, we're no longer accepting fax machines. I don't know how many people have fax numbers on their business cards. Things change, and AI will allow us to not just change brainstorming. It's going to allow us to change so many different things, and I'm excited about it, to be honest. But it's going to be a huge impact.
Liz, do you share Kelby's views?
Well, I might be a little naively optimistic, but in terms of the billable hour, I do see some challenges, but I'm hopeful that with the synthesizing tools of, AI, that more junior lawyers can use these tools to, cut down time that you would normally spend on something like a huge document review, where you're really looking at, non-relevant documents for hours, or, you leverage that tool to help you identify potentially the most relevant documents, the hot documents, and then spend more time actually looking at those relevant documents. Because I think a huge challenge is sometimes we get these large, data sets, and it takes so long kind of looking through them to identify the relevant documents, we really miss out on the time we could be billing and analyzing these documents more thoroughly and building our case. So, I'm hopeful that it will eventually even itself out, the extent to that which will be seen. But I think it's just going to take a little bit of creative thinking on our end on how we can sort of leverage these tools to be more efficient in areas that are excessively, inefficient, and sort of focus on things that really make us valuable as counsel. And so, I mean, maybe that's a little naive, but that's kind of what I'm hopeful for with these tools.
I think we're still very much at the adoption stage in terms of implementing Gen AI in law firms, and I'd be curious to hear you, Liz, on how is, for example, your firm evaluating which tool the firm will adopt internally? Are you putting together some sort of an AI action plan in that sense? What are some of the challenges you've seen professionals face internally when first integrating AI tools into the workflow? And also, you've mentioned junior professionals. How are we going to train them moving forward?
Sure. I think in terms of evaluating the tools that our firm will implement, I think it's been challenging. So I think I've mentioned that we are licensing attorneys for ChatGPT in particular, and that's the only tool that we're currently using. And it's just because there are so many tools out there. The proliferation of these tools is immense, and different practice groups are interested in different tools. And I was talking to our chief information officer, and she said every day she gets an email from an attorney wanting to use a particular tool. And, we have limited resources and only so much time. So I think the challenge is really understanding these tools, understanding their capabilities, and figuring out which tools will apply to the most lawyers at the firm and what will be useful. In terms of challenges that we're facing, I think it's just using the tools in the first place. I mean, Kelby mentioned that we're slow to adopt in the legal industry and adapt. And I think one of the tools has just been getting people to take the training and sign up for get a license. And then part of that kind of goes hand in hand with the training that you asked about. I mean, there is training in the sense of you need to understand the risks associated with ChatGPT, but really the training is you do it on your own. I mean, you just have to use the tool, understand how you can manipulate it, play around. And I think, when there's not a set training course necessarily, I think a lot of attorneys can find that challenging. So I think what we've seen is just people are slow to adopt it. People are slow to sign up for these tools that are available. And I think that's it's a real opportunity for junior associates to kind of get in early and really become experts in leveraging these tools. So I think that's a good summary.
Thank you. Kelby, any comments?
I agree with your points. And it made me think about, I still get asked to help an attorney here and there to PDF a document. So you definitely need to spend some time and learn the tools. I would take it further and say, I think it really needs to go beyond just the attorneys, because I've been now at the last two firms I've been at restricted only to attorneys. And we need to see different points of views, not only with our attorneys, maybe our experts, because there is such a bias as to what you say, how you ask the question can make a big difference in the result you get. And I think to this day, there are many people who receive an email and you asked this question wrong. So I gave you the wrong answer, or the answer that you just weren't looking. And ChatGPT is just going to take you literally just exactly the same way. So you really do need to invest that time in different levels, not just attorneys or just a set group, but really once you do, I think feedback amongst your colleagues is really important.
Jeff, we've talked about how law firms will train their junior associates, but as a professor at the university level, how are you viewing the incorporation of Gen AI into academia to help the younger generation face what's upcoming?
Yeah, I think both at Columbia and Harvard, the many professors are scared of it. And I think at the large law firms where I was a partner for 15 years, people are scared of it. Some lawyers and professors are early adopters. You talked about late adopters and early. Some of them are all over this, but some of them are scared of it. And I know at Sidley, there were some partners who couldn't PDF a document, and others that were adept. I do think that the law firms are conservative and cautious by nature. Lawyers are cautious people, and I think that there's some profit fears. I know that law firms used to make a lot of money on discovery, sending teams of associates to review boxes of documents. And there's a lot of profit to be had there. And then clients figured out that you could hire outside counsel, outside contract attorneys to review the documents for half the price or less. And then they figured out you can use computers to do it even quicker. We're now seeing the point where AI will do junior level associate tasks. ChatGPT, as of earlier this year, can now pass the bar in every state in America. And ChatGPT passes the LSAT at the 90th percentile, which may get them into a T14 law school. They're going to start creeping into things that junior associates could do. I think the partners recognize that they're going to creep into the things the partners could do, perhaps not in our lifetime, but soon enough. And so there are profit concerns as well about adopting this.
And then Jeff, from an arbitrator's perspective, what role, if any, do you see Gen AI might take in decision-making processes?
Yeah, I think it's coming. I do. I remember when people thought that chess would always be a human activity, that the computers would never be able to crack it the way human beings can. And for many years they couldn't. They got better and better at beating players like me, but the grandmasters would always win. And then I think it was 1997 when Deep Blue from IBM beat Garry Kasparov, and actually freaked him out at one point. In one of the games halfway through, he was, you could see it in his eyes. He's like, I don't understand what the computer just did. I don't understand that move. And they talked to him afterwards, and it threw him. He said, I have no comprehension of that. Then it must be much smarter than I am in order to think of that move, because I can't even explain why it did it. And it turned out the IBM people admitted that there was a glitch in the program, and it was stuck in an infinite loop, so it just moved randomly. And so, but he played really badly in the next game because of it. But now your phone will beat the greatest grandmasters in the world. I think it's coming in arbitration, in adjudication. I talked about the Silicon Valley rules. I think those are an interesting attempt at being specific on the role that we could restrict arbitrators to or guide arbitrators on. They suggest that you can't submit confidential information as an arbitrator, which I think is obvious, goes without saying. They say, and it puzzled me a little bit, that arbitrators do not have to disclose when they use artificial intelligence. And that was a choice Silicon Valley made. I think others may want it disclosed. Professors, often I require that my students, they can use it. I allow them using it, but they have to say what they used it for and what outputs they got. You're not allowed as an arbitrator under the Silicon Valley rules to rely on AI-generated information without notifying the parties and allowing them to comment on it, which would be my practice for any outside research, which, as I said at the start, I'm reluctant to do. If I think it's critical, I will do it, but then I'm going to give the parties notice and opportunity to be heard on what I found out. The Silicon Valley rules say you can't use AI to falsify evidence or mislead the arbitrator. I would hope that would go without saying. I was a little surprised to see that they thought they needed to be direct about that. And then they said you need to verify your output because you are responsible for it, which I think is also obvious. But that I think is worth underlining because people, when you see lawyers getting in trouble for citing hallucinated cases that don't exist, that'll be headed off if you make sure you verify. So the bottom line in these rules are AI tools can enhance efficiency and provide insights, but the arbitrator must make the ultimate decisions. And that I very much agree with.
I think we can open up the floor for questions. We have maybe time for one or two questions if anybody has a question in the audience or virtually, our virtual audience. Yes, sir.
I would just like to get also on institution and a government institution. If you want to provide your ideas about what other institutions.
Yes, if you press.
So my question would be related to arbitral institutions. If you have any thoughts about the role that arbitral institutions should play into maybe, well, either guiding or proactively implementing certain AI tools or standards, or your thoughts on that. Thank you so much.
Anybody wants to take this one? I can address it if you'd like. I just came back from ICC Miami, and they have announced that they've just launched an AI commission to look into these issues. I know ICC is also looking for, case management purposes to integrate AI potentially internally. But yes, the question is, who will be the leader in terms of putting together guidance, right? So is it the arbitration institution? Is it the IBA? I know the IBA has its own AI commission or task force. We've heard Jeff on the Silicon Valley Mediation and Arbitration Center that they've issued guidelines. AAA has issued guidelines. JAMS has issued guidelines. Thankfully, they all seem to be going in the same direction. But let's see how it evolves. Would you like to add anything, Jeff? Or
Yeah, sure. I mean, I've touched on that, and I agree with what you said, Annie. I think that the JAMS has got out in front of it in April, but with sort of a cautious and limited approach. Silicon Valley went a little further. Some of the courts that I talked about have gone, I think, too far. And there's a wait and see approach. You don't want to get too far out in front of it. If you ban it, you've banned too much. If you ban part of it, have you gone too far on that way? How do you define it is tricky. Do you mean to cover Google or search engines or spell checkers or just ChatGPT, and how do you limit it to ChatGPT? I think disclosure will be the first thing, requiring that you disclose it. But I wouldn't ban it at this point. I would put limits on confidentiality, which arbitral institutions already do. And I leave it up to the parties. I think we're not quite sure what we have with it yet. So I don't know how I would draft it. I think I would go with about what JAMS did and Silicon Valley did.
any other questions from the audience? Yes. Should we?
Hi, thank you for all the insights. Can you hear me? Hi, thank you. I thought I'd like to ask a question directed to all of you, which is, could you gaze into the crystal ball and tell us what you would like Gen AI or AI to be doing for you in your respective roles into the future that's not quite doing yet, or it's not fully developed enough to be doing yet?
Who wants to start?
Clearly, you still want to be employed. I know that.
I think.
That was occurring to me as I was thinking about your answer. You know, if this reaches all the way to the point where it's better, I had clients at Sidley who were coming up with algorithms that would diagnose disease. And some of them thought they would get better than doctors. If you can analyze the entire human genome and you have data from everybody's Apple Watches and wearables and billions of data points, you might be able to be better than oncologists. You find out every treatment for every genome, for every type of cancer that has ever happened in the history of when we started collecting data. Oncologists can't do that. And perhaps if the computers get there, they'll be better than the doctors. It will be malpractice not to go to ChatGPT to diagnose your cancer. And I can conceive of it in the arbitration world as well. And I was thinking about that on the subway this morning. If these things get good enough, the fight won't be over which arbitrator you choose, or do you go with JAMS or some other organization. It's which algorithm do you choose? Which large language model do you choose? The fights will be over that. I think it'll be my children or grandchildren's generation that struggles with that, but I wouldn't be surprised if it comes, unless something blows up, unless something it craters in some reason. Confidentiality. There's lawsuits against ChatGPT for ingesting copyrighted information. Perhaps some court will decide that the whole system is not viable. But short of that, I expect incremental progress until it gets like the chess computers.
I hope we'll see better access to justice, frankly.
Yeah, it's cheap and quick and transparent if it's done right.
I mean, part of our mission at Use Mundi is to bring more transparency, accessibility to the law, empower the global rule of law, really. I think, down the road as Gen AI is able to complete more complex legal tasks. I think, it'll be and perhaps law firms will start adapting their business models, not, billing per the billable hour, but through other types of business models. Potentially some of the underserved types of clients, consumers or small, medium-sized businesses might have better access to legal representation thanks to these types of tools.
I think I would add 3 things on that wish list, on my wish list especially. One, I would love for AI to somehow connect us better. I love networking as much as the next guy, but trying to meet 100 people in 1 week is very hard. You only get to meet like a handful. And so finding those genuine connections that you're looking for, I think AI has value, has the potential, but that would be on my wish list. Second thing, citations. We grasp on these blue books or Chicago manuals and all this stuff when really many of us, at least in arbitration, we submit the document, like where are we on these citations? Everybody has a different style and we spend a lot of time on them. The blue book is on their 20, I don't know, something edition, so they still can't figure it out. And third is how we write. And we still write very much like we're still on a typewriter, just a very fancy typewriter. There used to be, several years ago, the opportunity and ability to create things on either an iPad or something like that, where you could, as you're talking, the terms would pop up, or you're referencing a document, the document would be embedded in there. But we're still very reliant on our paper, so we go back to typing on a typewriter, and that really limits the potential of how far we can go, and how much we can read, and how large these briefs need to be. So I would hope for AI to somehow help us revolutionize that area.
Liz, you have the final word.
I think I would, echo what everyone said. And I agree with Kelby. I wish I could leverage the AI tools to help with business development in some way. Maybe I'm just not creative enough to think of it, but I think that's always the challenge in the legal profession. So I think that's something I would focus on. I find it very useful for like my everyday tasks.
Okay, well, thank you very much. Please join me in thanking our panelists. And thank you for joining us this morning, both online and in person. Thank you.
We'll break for about 10 minutes and then we'll start the next panel up. So please help yourself to beverages, food. We'll get started soon.
Great, thank you. That's fun.
This is going to be a perennial panel. Yeah.